Access to Information, Privacy and Ethics, conformément à l'ordre de renvoi de jeudi 12 février 6 et la
Pursuant to the order of reference of Thursday, February 12, 2026, Section 14.1 of the Lobbying Act and the motion adopted by the committee on Wednesday, September 17, 2025, the committee is resuming the statutory review of the Lobbying Act.
Before I introduce the witnesses, I'd just like to remind you that committee members may ask questions in either English or French. And if you do need interpretation, just take a moment to listen to the entirety of the question before the response, because sometimes that affects the time allotted for questions, okay? So I try to be as fair as I can. If there is a question that needs to be answered, I'll extend the time if I have to. And I would like to welcome our witnesses for today as an individual. Jacques J.M. Shore, who's a partner at Gowling WLG, Suzanne Sabourin, legal counsel, Gowling WLG, and from the Canadian Federation of Independent Business, Christina Santini, who is the Director of National Affairs. I want to welcome you all to committee. Ms. Sabourin, vous avez jusqu'à 5 minutes pour votre déclaration, si tu veux.
Ms. Sabourin, you have up to 5 minutes for your opening remarks. Thank you, Chair and committee members. It is an honor to address you as part of your legislative review of the Lobbying Act, alongside my colleague Jacques Shore. My testimony today represents my own views and not those of my law firm, my clients, or any third party. I was formerly a staff lobbyist, and I am now a consultant lobbyist. As a public law attorney, I advise businesses and nonprofit organizations on lobbying legislation at the federal, provincial, territorial, and municipal levels. I work at the intersection of conflicts of interest, ethics, election lobbying, and now on the relationship between the Lobbying Act and the Transparency and Accountability Act on foreign influence. The scope of the Lobbying Act is very broad. The proposed amendments proposed by the Commissioner of Lobbying must be evaluated to ensure real transparency, accountability, and to ensure full democratic participation. Let us turn to some of the proposed amendments. First, I do not object to registration by default being the standard under the Act. In my view, any changes to the registration threshold must be made by Parliament and not through an administrative directive from the Commissioner. The 2023 amendments to the Lobbyist Code of Conduct raised similar concerns. The code equates the sponsorship of public forums with the rules on low-value gifts and low-value hospitality, risking the stifling of legitimate dialogue. I looked into this in depth for the last 2 years. These limits would hinder essential dialogue in public forums where government officials, academics, and community or business leaders debate policy. Rather than limiting undue influence by imposing these strict rules, they risk reducing transparency. I believe that the right approach would be to prioritize transparency through reasonable and clear standards while avoiding restrictions on legitimate engagement, provided it is disclosed under simple guidelines following public consultation. The exemption provided by the Act regarding briefs submitted to parliamentary committees offers a model to follow. Second, the reforms impose a heavy administrative burden that affects all stakeholders, not just large businesses with multiple lobbying mandates. It is not enough to simply deal with compliance officers at the Office of the Commissioner of Lobbying of Canada to complete and submit a disclosure to the public registry. Compliance requires an ongoing monitoring process to account for internal changes, update disclosures, and reconcile disclosures with monthly communication reports in the prescribed format and within the prescribed deadlines. All of my clients recognize the importance of the Lobbying Act and comply with it. As outlined in Imagine Canada's written submission to the committee, Canada's nonprofit sector comprises over 170,000 charities and nonprofit organizations, and many of which engage with the government regarding grants and contributions as part of their operations. These reforms must include a reasonable de minimis threshold to avoid imposing disproportionate compliance burdens on routine administrative interactions. Otherwise, organizations seeking funding to provide their public interest services would be subject to the same registration and reporting obligations as those seeking major government contracts, which would create an incongruous outcome that does not reflect the relative importance of the underlying activity. Third, several reforms raise questions of procedural fairness and the limits of administrative power. BC's Lobbyist Transparency Act serves as a model for additional compliance measures by stipulating clear procedural steps, legal safeguards for the administrative process, public guidelines, and a timeline for judicial review. Furthermore, granting the Commissioner independent regulatory authority is incompatible with parliamentary accountability and the fundamental principles of Canadian administrative law. As you know, those who enforce the law should not also make it. Finally, several reforms would create a super registry that is overly broad and obscures rather than clarifies interactions critical to public accountability, which risks undermining rather than strengthening democratic governance. For example, including Director General positions as designated public office holders would significantly expand the disclosure framework and post-employment restrictions, diluting the targeted oversight of senior officials. Requiring monthly reports on all communications for all lobbying with designated public office holders, such as Crown ministers, whether it be oral, written, informal, or prearranged, this is fundamentally impractical. This eliminates the scope for reasonable judgment on the part of office holders who are elected, appointed, and recruited precisely because they are expected to exercise sound discretion in the public interest, and risks overwhelming the system with low-value disclosures that obscure truly significant activity. Requiring the disclosure of all lobbyists present at meetings imposes a heavy compliance burden while diverting attention from the key players in lobbying. As noted in our brief, a regime that tracks everything tracks nothing of particular significance. The current regime has struck the right balance. With that, I would be happy to answer your questions. Thank you, Ms. Sabourin. Your opening remarks took a little bit more than 5 minutes, so I'll ask Mr. Shore, if you can, take a little bit less time, maybe 3 minutes with your opening remarks, if possible. We would appreciate it. Mr. Shore.
Made sure I tighten as much as possible in terms of the points. So I'll talk quickly. How's that?
Right, thank you.
I appreciate it.
Right.
Thank you so much.
We have copies of your
Thank you.
declarations.
I've added a bit more. Thank you very much, Mr. Chair, honourable members of the committee. C'est vraiment un grand privilège d'être ici devant vous.
It's a great privilege to be here today, this afternoon.
Look, for 3 decades, I've emphasized the importance of transparency in dealing with government. And throughout my professional practice of law, I've had the honor of working with elected appointed parliamentarians and public office holders, both as legal counsel to government and representing my clients on matters of law and public policy as legal counsel, in addition to advising clients on their legal obligations under Canada's lobbying regimes. I also note that I previously appeared before a parliamentary subcommittee in October of 1994 when proposed amendments to that lobbying registration framework were under consideration. And I drew my experience on a number of things that I'd done in government and also in my early days of practice. There's no question that while many years have passed, new and innovative ideas to government remain important, and my deep commitment to the foundation principles of transparency in our democratic process remain the same. Let me begin with a preliminary observation concerning solicitor-client privilege. This issue arises in relation to several of the Commissioner's recommendations pertaining to expanded disclosure obligations, including those concerning the disclosure of funding arrangements that support lobbying activities and reporting communications with designated public office holders regarding awarding of contracts. Canada's lobbying framework has long recognized the critical role of legal counsel in the protection of confidential communications. It is essential to recall that solicitor-client privilege exists to protect the client, not the lawyer. Where a client consents to disclosure, the issue does not arise. However, in the absence of such consent, compelled disclosure will undermine the privilege itself. This risk and the slippery slope of interfering with this recognized historic privilege should be carefully considered. In that context, I would suggest that the committee consider a mechanism similar to that which exists in Quebec, allowing on an exceptional basis for a temporary deferral of public disclosure in cases involving highly sensitive or commercially confidential information, where premature disclosure could result in significant harm. This type of deferral should be limited. And it really is in cases where there really is, I think, an important legitimate public and economic interest involved that should not be jeopardized. More broadly, I would submit that our lobbying regime should reflect a baseline level of trust in the integrity and judgment of public office holders and those speaking to government. A system premised on excessive disclosure because of an underlying or perceived mistrust may discourage engagement and, in so doing, undermine the public benefit and the very democratic process it seeks to protect. It is also important to view the lobbying regime within the broader framework of accountability measures, including conflict of interest rules applicable to public office holders and those who deal with government officials to advance legitimate objectives and nation-building exercises. And I want to emphasize transparency is one component of a larger system of integrity and should not be treated as an absolute. To inculcate a common purpose to do good in the context of economic growth and nation building should also be viewed as a key societal goal. I would also emphasize the importance of respecting institutional roles. Parliament, as we in our report, we put it very clearly. It should be, while certainly respecting the Commissioner of Lobbying, she should not be granted the opportunity to create independent regulation-making authority. This is essentially up to Parliament and up to the Governing Council to address. Otherwise, it would be inconsistent with Canadian administrative law. Finally, I would vigorously caution that this exercise not lead to the expansion of the categories of designated public office holders. Respectfully, believe that such expansion will impose unnecessary burdens and will discourage interaction, important interaction that's for valuable dialogue with officials to test or to consider new ideas before raising them further at more senior or political levels of government. It may also extend to post-employment restrictions to individuals in ways that would discourage people from wishing to work in government, especially those who intend to engage in public service, not for their full careers, but for limited periods of time. So, avec ça, je vous remercie encore pour l'opportunité de parler avec vous aujourd'hui.
Okay, thank you, Mr. Shore, and I'll be certain you get a participation ribbon for that one because you're under 5 minutes, which is perfect. Thank you. Ms. Santini from the CFIB, go ahead with your opening statement.
Bonjour, je remercie sincèrement le comité pour cette amiable.
Hello, I would like to thank the committee for this invitation. The Canadian Federation of Independent Businesses represents more than 103 small business owners in all sectors of the economy and in all regions of Canada. More than 52% of our members have 9 members or fewer. So this means that they are truly small businesses.
Will be in English. Small business owners work an average of 54 hours a week and wear many hats, managing staff, sales, finances, while serving their communities as your local shops, your local service providers, and your local employers. They are remunerated by their business either as an employee or as a shareholder. In July of 2025, the Commissioner of Lobbying issued an interpretation bulletin, which lowered the registration threshold for organizations and corporations from 32 hours per month to 8 hours in any rolling 4-week period. The new threshold and proposals to move towards registration by default that would encompass all planned and unplanned written or oral registrable activity is concerning. Why? These changes risk unintentionally capturing ordinary small business owners as lobbyists. From time to time, a small business owner contacts their federal MPs or minister to raise concerns and make recommendations relating to policies that affect their business. Or they apply for financial supports in relations to their business. They now need to register if they and or their employees have collectively spent more than 8 hours researching, drafting, and sending these communications. We are already hearing from business owners who are surprised to learn that writing to their MPs or applying for support programs could require them to register. They do not see themselves as lobbyists. They are simply trying to run their business. They believe they are raising concerns about government policy that affect their business as constituents. One practical measure that would help reduce red tape on small businesses would be to exclude time spent applying for grants, contributions, and other financial benefits from the registration threshold, particularly where there is a public, rules-based, transparent process. Applying to such programs is not an attempt to influence decision. It is participation in a process created by government. While we support the idea of transparency, we also caution about how it is sought. And as such, CFIB recommends not pursuing registration by default and legislating the threshold, specifically the former 32-hour threshold. Changes to this threshold should be reviewed and debated by the House of Commons and the Senate and not left to the purview of the Commissioner. Further, only requiring planned communications organized for the purpose of influencing policy and procurement decisions should be reported, not unintended or haphazard meetings in a community barbecue, for example, that weren't planned and where certain topics may be raised. We also, of course, support the suggestion of excluding the time spent preparing and submitting requests for grants and contributions when they're part of a government process. We would also suggest or recommend that clarity be provided to stakeholders so that they could properly assess the potential impacts of some of the other recommendations made by the Commissioner of Lobbying. For example, how would grassroots lobbying be defined and what would include? Surveys, petitions, letters, communiques? We regularly get told that MPs want to hear directly from their small business owners in their writing. These changes and the associated administrative burden risk discouraging that engagement. Consequently, those with the time and resources to navigate administrative requirements will be heard. Others may opt to be silent. Transparency should shed the light on organized lobbying, not create barriers between small business owners and their elected representatives. Thank you, and I welcome your question.
Okay, thank you, Ms. Santini. Before we begin, I'm just going to ask members as they're asking their questions to direct them to the specific person so that there's no delay. And we're going to start with you, Mr. Cooper, for 6 minutes. Go ahead, sir.
Thank you, Mr. Chair. I'm going to direct my questions to Madame Sabarin or Mr. Shore, whoever wishes to answer. I've read your fairly comprehensive brief. I want to ask you some questions about Recommendation 12 of the Lobbying Commissioner with respect to reporting. You state in your brief that the current framework that focuses reporting requirements on oral and arranged communications appropriately balances transparency objectives with the practical realities of governance, and that the recommendations of the Lobbying Commissioner with respect to reporting are fundamentally impractical. You said that in your brief. You said that in your testimony today. Now, the Lobbying Commissioner has made a number of recommendations around reporting, but in recommendation number 12 specifically, it looks pretty straightforward to me, which is simply that communications, oral and written, would be captured, and that what would need to be registered is that a communication in respect of what in substance is lobbying took place, as opposed to who initiated it, whether it be the lobbyist or a public office holder. So in respect to that, let's just take a public office holder who initiates the communication. What is burdensome about then having to report that?
Well, it's not the fact that a public office holder initiates the communication. What we are arguing is that when you lump in the fact that the communication does not need to be prearranged or does not need to be organized, it creates a lot of difficulties. Firstly, I think you all know that the definition of lobbying is rather wide. So, no, but it's just that in terms of you're denying the office holder, whether it be a public office holder or the designated public office holder, to exercise his or her own discretion to determine if this is lobbying. Then you complicate the matter in terms of what interactions. You know, a simple meeting at a barbecue.
Let's just start. There's a few pieces to this, so let's start with the first piece, and that is who initiated it. Do you think that it is reasonable to require that it be reported on if, for example, what in substance amounts to lobbying is initiated by a public office holder? Yes or no?
Yeah, go ahead.
Yeah, I'm happy to. I think it really gets down to what is the role and duty of a public office holder. But a lot of that has to do also with being able to gather information, to be able to weigh issues, understand what they are. If what you do is you start creating a real formality to the engagement with the public, and I think that adds, new layers to it. And that public officer, we're very, we say so generally, it's not a designated public office holder, but let's say someone who is at the DG level. Those are important positions.
It seems to me to be rather an artificial test to base whether to report or not report on who initiated the communication. It seems to me that what is material is not who initiated the communication, but what the substance of the communication is. Is that not fair?
I don't. My sense is that it is important as to who initiates the communication for a particular purpose. And under the Lobbying Act, those individuals or those who wish to engage, to communicate, you remember the previous act actually made reference to influence, and that was actually deleted to simply make it to communicate. I think that's strong enough in terms of who out there is communicating or addressing issues with government officials for a particular purpose. And I think that's where I would draw the line. I also tend to think, as someone who worked in government before, that I would not want to find myself having to think about I have to set out every conversation I have in a day when I'm reaching out to someone in the public to talk to them about something that I'm working on to help me engage in policy.
But let's face it, lobbyists are sophisticated. They know the lay of the land. They know Ottawa. They know where to find public office holders. Why, for example, should a lobbyist get a free pass from registering or reporting a communication with a public office holder at a reception or at an airport lounge?
So
lobbying is lobbying.
So, Mr. Cooper, this is where perhaps, with great respect, I disagree. Not all lobbyists are sophisticated professionals. Lobbyists are those who are identified as actually having a communication with the government, and that could be the person that basically meets for the first time, someone who wants to address an issue that comes up with a small business they have or whatever. They're not a lobbyist, but they're bringing up particular issues of importance to them. It's interesting. I am obviously on occasion, rarely, but often I find myself, it's where I'm representing a client's issue that may deal with a policy or change in legislation or whatever, but I'm a lawyer that has that obligation in the context of lobbying. So there's a difference as to who it is, and I think that we shouldn't make it so difficult for those and imagining that those are so
Thank you, Mr.
sophisticated
Short.
that they'll know exactly what to do, and then make them quiet to not engage in the conversation because they know they've got to do something, but they just
Thank you.
don't know what.
Thank you, Mr. Shore, Mr. Cooper, Madame Lapointe. And just before I go to Madame Lapointe, you are all experienced. You've probably been at the committees before. You know the members are fighting for their time for 6 minutes or 5, so sometimes they cut you off. Don't take any disrespect intended for that because they're trying to make their point as well. Madame Lapointe pour 6 minutes.
Merci beaucoup, Monsieur le Président. Bienvenue à tous les témoins. Très intéressant tout ce que vous dites.
Thank you. Welcome to all the witnesses. What you've been saying is very interesting, that things aren't as simple as they seem, that there is no perfect definition for a lobbyist or when one is lobbying, especially if we're dealing with the medium and small businesses. If you speak to your MP, you want to raise an issue, is that lobbying, yes or no? So I heard you. I was an entrepreneur before my career in politics, and that nuance is quite difficult. I read your biographies, and they are quite impressive, and it's very important to hear from expert witnesses. Given your experience with the Lobbying Act and lobbying in general, could you help the committee to understand why you're qualified to be our expert witnesses today? I'll start. As you can tell, I was not born yesterday. I've been around, and so I started when Mr. Mulroney tabled the first legislation on the lobbyist registration. And so as I worked as an in-house lobbyist and then a consultant lobbyist. I have always worked on different files. And now I'm lucky enough to work with different stakeholders in the private sector and civil society and people from from different organizations. So I get to work with the different levels of government as well, provincial, municipal, all of that. And so now we are looking at the potential impact of these changes, and if we include external influence. So these are all things that I have experienced. I've focused my comments on what I have experienced and what I've heard, and I am constantly reflecting on these matters. I often work with these compliance officers to clarify any issues, understand any complicated problems. Do you have anything to add, Mr. Shore? I could add that for the last 35 years,
legislation from way back, dealing with the lobbying registrar, as the lobbying registrar was then called, also advising the office of the lobbying commissioner here at the federal level, also working at the provincial level too, also in terms of assisting clients that have actually been penalized for the way in which they may not have addressed the detail of the legislation, but more so because of the privilege of the practice of law that I have, which is an advisory component and a component where I'm dealing with major issues. When we deal with government, I also have to be very mindful for myself. So I find myself both having to ensure that I am, on those occasions where I am lobbying, and I put that in quotations, I'm an advocate, whether I'm before a minister, whether I'm before a judge, or if I'm before, to me it's the same in a sense. It's my factum that I'm sharing in terms of educating the particular individual in government that I deal with. So I have to make sure the letter of the law, and as a result, I've been called upon for my advice and making sure that clients do respect the letter of the law as well.
Merci beaucoup. Puis, dans votre mémoire que vous avez soumis au comité,
thank you. In the brief that you sent to the committee, you highlighted the importance of not having a system that is too heavy and that hinders legitimate lobbying. Do you believe that lobbying is essential to modern democracy? And if so, why? And what would be the impact of having a lobbying regime that is too heavy? To answer your first question, yes, lobbying is an important activity. I am more of an advocate than a lobbyist. My goal is to represent my clients to the best of my abilities. In a democracy, this leads to political commitment, clear commitment. It allows us to share different points of view in order to find the best possible solution that would be in the public's interest, and it is essential. Mr. Shore.
C'est essentiel que
It is essential for us to debate and have discussions with government and the public. I agree. Nobody has a single solution. It's only in hearing the different points of view that we can find the best legislation possible. Throughout Parliament, everyone has different opinions, but perhaps in discussing all of this, we'll find a solution.
balance that we have here. I think that what is being proposed, respectfully, my view is that we will go overboard. We will do more than is necessary. We want to make sure the public understands that transparency is important, but we also want it to be understood there's integrity when we deal with public office holders. And on the other side as well, I do think there's a suspicion that when lobbyists are speaking to government, it's something that's sinister, and it's not. It's about the exercise that's necessary, I think, for government to better appreciate all sides, all issues.
Thank you, Mr. Shore. Merci. Merci, Madame Lapointe. Monsieur Fortin,
Thank you, Ms. Lapointe. Mr. Fortin, you have the floor for 6 minutes. Thank you, Chair. Ms. Sabourin, Mr. Shore, Ms. Santini, thank you for being with us today. Ms. Santini, if I understood correctly, your organization is against registration by default. Did I hear you correctly? The microphone was not on. Why? I'm not an expert in lobbying, and perhaps I'm wrong here and you could let me know, but the issue of the thresholds is an issue, how to manage 32 hours, 8 hours, and many countries will be using that registration by default, and that seemed like a good idea, but could you explain why you're against registration by default? Often, a small entrepreneur will have an issue, they will receive a call from an employee, or perhaps policies have changed. I'm going to switch to English if you will allow it.
They'll have an issue. They'll raise it with their local MPs, and sometimes they'll also ask or state this policy should change. These are the recommendations I would make. We would not want that sudden discussion to suddenly, through registration by default with no threshold, mean that they suddenly have to register and put in that communication, when right now that conversation would have taken, 30 minutes? And they wouldn't have had to set up a profile. They wouldn't have had to report that exchange. Now, they're venting their frustration. They're putting in a recommendation as a citizen. They're a business owner trying to operate their business, and they're frustrated with a specific policy change that's been brought forward. Registration by default would mean, given that they're remunerated by their business, they have to declare it. They're an in-house lobbyist. That is a concern. Even bringing it down to 8 hours is a concern, because we have some members that have faced serious issues. They've, are very concerned about the future of their business, and they've communicated with their MPs and tried to get meetings, and they've also set up or been able to meet with the minister, and that becomes lobbying, especially as soon as they get to the 8-hour threshold. But they're only looking at their specific case or how policies apply to their specific case.
Je m'excuse de vous interrompre, comme le disait M. le Président.
Apologies for interrupting you. As the chair said, we are short on time, and sometimes we have to cut you off. What would you recommend then, in a few words? We're asking for the threshold to be legislated and that it be over 8 hours. 32 hours would be better. And if you're applying for a grants and contribution, Canada Summer Jobs, for example, that shouldn't be an activity that's considered lobbying. It takes a lot of time to fill out those forms. Ms. Sabourin, Mr. Shore, do you agree with Ms. Santini on that? I agree in that the threshold for registration should be legislated through Parliament, and it needs to happen following a consultation on potential impacts. We saw the 32 hours. Now we're seeing how things are going with 8 hours, 4 consecutive weeks. Is there perhaps a middle ground? Are there any options for nonprofits? Without going into detail, I know that BC has a special committee that is focusing on their legislation in order to make recommendations in order to lighten the burden on nonprofits and small businesses.
Important
Oui.
that there be a consultation. This needs to be addressed. I would like to know how members of Parliament feel about that. I'd like them to know how they would feel about their constituents suddenly being put in this position. And it requires, I think, good debate.
Merci. Je change de sujet.
Thank you. And now I'm going to change topics. The Commissioner recommends that board members be considered employees. What do you think of that, Ms. Sabourin and Mr. Shore? Honestly, I was able to listen to the testimony by the Honourable Joe Jordan, and I appreciate his recommendation. It's practical and reasonable.
Something else, though, it'll certainly be important for all of those boards that are out there for them to ensure that their directors appreciate what that is. My concern, I guess, is that when you have voluntary boards and you have boards where you have individuals that are dealing with matters that are of importance to them, for them to feel that if they run into their member of parliament or they run into a minister and they have the opportunity to say something that is important, for example, with regard to a cultural issue, with regard to a particular issue dealing with homelessness, and they have to now suddenly register, again, I wonder what the value is of that, and I certainly wouldn't call that person the employee, and I would make sure that it would be understood as an exception to the rule. It's not an employee, it's a director, but I think that's worthy of debate as well.
Merci. Rapidement, Madame Santini, sur la même
Ms.
question.
Santini, on the same question?
Parle de quand il y a
When there's an informal interaction, when do you have to include it? There needs to be the possibility to have that communication as an individual. Consultations would be welcome. Is my time up? 10 seconds. The registration process, it takes about 20-25 minutes, I think you said. Does that seem reasonable to you? It's more than that. Oftentimes, you need to have all of the information, and that can take some time to have all of the information that needs to be registered. It's also very complex. It's hard to understand which activity is included. Thank you, Chair. Thank you, Mr. Fortin. This completes the first round of questions. We're going to start with our second round of questions for 5 minutes. Mr. Hardy. Thank you, Chair. Thank you to the witnesses for being with us today. I've been listening attentively. I've always said that democracy is as strong as it can be when people are informed. It is important to be transparent. So you think that in making it more official, asking people to be transparent, that will block the democratic process, and that will make people less likely to reach out to their MPs. And I just want to make a comment. If somebody comes to speak to me about an issue, they're not meeting that 8-hour threshold. They're just talking to me about an issue, and I'm going to continue working for that person. So if you're officially doing more than 8 hours of lobbying, how is that something that shouldn't be controlled? It's a bit of a side job at that point. We were talking about registration by default. That's 0 hours. That's what I had understood, that everyone needs to be registered. I asked the question to the Commissioner of Quebec that whether or not this would slow things down. The Commissioner said, you just said who you met and what the topic was, and that's it. What we're looking for here is because lobbying, we know, is a good thing. As MPs, we don't know everything. So making it complex is not something that we want, but we want to make it more transparent. You're saying that it's too complicated, that it should be 32 hours, but that would be meeting the target, missing the target as well. I can answer. When the administrative burden is too heavy and not necessary, it doesn't add any value to transparency. In fact, it undermines it. If it becomes complicated, yes. Well, I would tell you that it might already be complicated. It's certainly not simple in Quebec. I'm constantly helping people out in Quebec. And it's more than 5 minutes. Well, I get the impression that there are associations that can represent different types of businesses, and so there needs to be an efficient structure to follow the rules. And people are losing trust in their institutions. We know this. They feel that decision makers are making decisions to benefit themselves. So we need to ensure that there is transparency in lobbying and that we are aware of everything. If you're asking for a contract from government, that's not considered lobbying, and that's a big, big issue right now. And if we have to talk about 32 hours, that's even more complicated. If you're doing some lobbying, why not have something simple? You met with someone. I met with this MP. I spoke up to them about this topic. It doesn't need to be a 100-page document, but there needs to be registration. I agree with the registry, and I agree that transparency is important, but as we said earlier, we would also need to review the Lobbying Act because currently it includes communication with public office holders or designated public office holders, and there's a whole list of the types of communication that you're legislated. And I can assure you that even though there's a list, and I'm speaking on behalf of industry and nonprofits filling out those reports, it's not that simple. They'll say, well, I talked about this topic, but it was more giving information. I wasn't looking to make any changes. I understand that, but I don't think that people are looking for billions of dollars. In your report, you say that trust by default should be at the heart of this. That's what you said? Yes. At some point, we have to focus on this. The Prime Minister was at the head of a business that was constantly avoiding paying taxes, and we need to rebuild people's trust because of situations like this. I understand that someone might find the process complex, but we don't want there to be lobbying, billion-dollar lobbying happening. I don't want to minimize the importance of transparency, but regulating might not be what you need. The Lobbying Act, well, you have to look at it as it intersects with other legislation. Conflict of interest, for example. It would need to be aligned with the Conflicts of Interest Act. I'll carry on. No, you can't. Not even a little bit? No. Maybe in the next round, though. Not now. Mr. Al-Sood. Apologies, Mr. Hardy.
Sood, you have 5 minutes. Go ahead, sir.
Thank you, Chair, and thank you all for taking the time to be with us today. Mr. Shore, Madame Sabourin, I have in front of me your brief, which you submitted ahead of today's meeting, and I'd like to take a moment to thank you both, because it touches on quite a few valuable pieces here, and certainly highlights your knowledge on this topic. Now, in that brief, you make mention of the importance of avoiding a regime where the compliance burden actually ends up deterring legitimate engagement. It's taken up much of today's conversation. I want to latch on to something you said earlier, Mr. Shore, which I think is an important note on the value of lobbying within our democracy. To your point, many associate it with something sinister, as you said, but as I was out on a walk the other day, I stepped into my local Java U, which I will add is much better coffee than what we have here on the Hill, and in that short time, they highlighted a parking challenge they have. Now, That's municipal jurisdiction, obviously. But I'm quite happy that they felt comfortable speaking with me, engaging with me. They didn't feel like it was going to lead to this pile of paperwork after the fact. So I'd like to offer you the opportunity to expand on the importance of this legitimate engagement, and perhaps on what most don't recognize as important in legitimate engagement, how you believe that overly onerous compliance might challenge this.
I love that, Mr. Al-Sud. I appreciate you asking that question. Look, I mean, we live in a blessed country. I think we live in a country where we can pretty well expect that our public office holders, members of parliament, our senators are there because they want to advance this country. They want to do good, and they want to be able to help families grow and do well. And I think in that context, those that I've had the privilege of working with and seeing and dealing with daily, I see they're interested in the public. They want to pull in that information so that they're better understood. And how wonderful it is when the public also feels there's a comfort level without an obligation that suddenly requires that they do something. To the point that was made earlier about, sophisticated lobbyists, of course there are those advocating positions, they understand it. But when we suddenly move from that realm into one that basically pulls in a whole new audience, a whole new public, I worry about that, because that's where I see people wanting to be quiet because they don't want to break the law and they don't want to get in trouble. And the public office holder doesn't want to get in trouble either. They suddenly have an obligation. I don't come across, frankly, I never come across a position, if I may, to Mr. Hardy's point, who say quelque chose qui est caché. We're not hiding. I don't see a lot of people hide. I don't see people hiding information. They're perfectly happy and legitimately, when they go before government, because they know there's an obligation, there's something serious to address, they will register. They will ask for advice. They will seek the assistance of Madame Sabourin or others to address that. So I think what we need to do, and that's why I sort of made that reference earlier, we want to inculcate the context of moral behavior that with integrity that engages people. If there's a question about an individual who had worked in a corporation previous to coming to public office, and I applaud the people that come to public office from corporations, they shouldn't always feel like they're suspect. Well, they can stand up in the House of Commons, they can be asked the question, and then they can answer it. And that is the public engagement that I would expect, rather than necessarily relying on a lobbying commissioner to address particular detail. The other thing, I don't really want to see, we don't have telephone directories like we once did. What's the value of a telephone directory that this high for every communication that goes through, rather than this big for the communications that are important for us to study and understand? So I think that's where there's more than a limit we need.
Thank you, Mr. Shore. Ms. Santini, Mississauga is one of the fastest growing cities in our country, and Mississauga Centre perhaps especially. During my first committee appearance on this study, it might have been my first question. I recall asking about the importance of ensuring that our system recognizes the inherent value of small businesses. In the time that I have left, roughly a minute, I'd like to offer you the opportunity to speak to us about the important role that small businesses play in Canada, and also help this committee understand why it's so important that any lobbying regime not become overly onerous for small businesses.
Absolutely. Small business owners, as a reference, they already have a 54-hour work week. They employ 64% of Canadians in the private sector. They contribute enormously to GDP and just the feel of our communities. And yeah, you can walk into your JVU and they might raise something that has to do with a federal issue. Do you want to then be in the position to turn around and say, hey, great, thanks for telling me. Now, I need to tell you, you should probably call the Office of the Commissioner of Lobbying to see if you need to register this intervention. Imagine how that member, that constituent, is suddenly going to feel, it's like, wait a minute, I'm paying my taxes, and yes, I'm asking something on behalf of my business, but now I might suddenly have to do a whole bunch of red tape. Next time you walk in, he might have an issue, but he might not necessarily want to walk right in on it or mention it. Is that helping democracy? Is that helping the public dialogue? Is that helping you in your positioning and in your work to represent your constituents?
Okay, thank you, Ms. Santini. Mr. Al-Sud. Monsieur Fortin, j'ai juste 2 minutes 30 secondes.
Mr. Fortin, 2.5 minutes. Thank you, Chair. I didn't have enough money to buy 5 minutes, so I'll just have to deal with 2.5. Thank you. Can you talk about these disclosure when you ask at large whether or not somebody wants to speak to a minister, and that grassroots lobbying. It is a legitimate question, and it is part of the lobbying regime. It is a way to communicate. It is legitimate. Again, defining that, there would need to be public consultation to do that, and not only be included in the Commissioner's directives. You talk about public consultation, I assume you mean with lobbying organizations? No, when we're talking about legislative amendments and public consultations, well, when you're looking to review it, there's an opportunity to host consultations with the Canada Gazette, for example, or other parliamentary committees. You seem to be expert enough to advise as well. Ms. Santini, same question for grassroots lobbying. It's generally available. Comments are published in the Gazette. Why add to the burden? An organization that asks the population to write to a minister for specific issues, should this be part? It needs to be, grassroots lobbying needs to be defined then. Because when we saw that suggestion, we said, well, we do what we can. There are surveys, and do we need to declare every question asked? Are surveys part of grassroots lobbying? Or is it just when you're sending letters that's registers? Do you register each letter? So there's a lack of clarity, and that is what we brought up in our brief. We wanted to understand how it would be implemented. The devil is in the details, as we say. Mr. Hardy, and then we'll end with Mr. Chang. Mr. Hardy, 5 minutes. Thank you, Chair. I want to come back to where I was at before. Mr. Shore, you were talking about Parliament as being the place that has all the power. I've been here for a year. Ms. Sabourin, earlier you said those who apply the rules can't be those who are making them. So, those who are subject to them shouldn't be making them either. So, as a committee, we are speaking to witnesses, and we just had that here where a debate was shut down and moved in camera. How can we hope that we will have 100% transparency when those who are subject to the legislation have an impact on what's being voted on in Parliament? I've asked that question many times, whether it be to the RCMP or to others, and the commissioners saying to change the legislation. But if we change the legislation, well, it's up to the majority government to make those decisions. I believe that our Parliament should be focused on people. But how can we ensure that transparency when there's an issue with the mechanism?
That we obviously have significant ways of communicating today, whether it's through this, or whether it's through grassroots lobbying, through a whole range of various areas. And I think that to a great extent the public is aware when there are discussions that are going on with parliamentarians. I think to a great extent what we're looking at right now is a set of circumstances where we want to find the right balance. The fact that this committee is doing the work that it's doing right now in the public arena is extremely important. The fact that this is also an opportunity, through, for example, the work of Christina Santini, to be able to, provide the information with respect to her members, for us to be able to reach out to clients and Hill Times articles that we've written. I do think that at the end of the day, what it is the back and forth, and then finding that if I would say that delicate balance to
Vous
that.
parlez de la transparence, c'est ce
Oui,
qu'on demande.
no,
Mais tu sais,
absolument.
8
We're
heures par...
talking about transparency, but 8 hours a month, that was decided on by an independent commissioner. Do you believe that commissioners should have more powers? No. But yet each commissioner who is independent has said to us that in order to be more fair, they need to have those powers. We are an oversight committee here. We are the ethics committee, and we don't even have the opportunity to hold people to account.
I'm perfectly glad that they are
Non, mais tous
actually,
les commissaires sont indépendants du
But
Parlement.
all
Je parle pas...
commissioners are independent from Parliament.
the way in which they advocate and say that there should be further transparency by expanding those rules and opening them up, I can understand that they may want to say that, but then there's a dialogue to determine as to whether or not that really does make sense and whether it'll make a difference. Because I do think that it becomes ultimately to a point where it's overburdened, and in the end of the day, all that information, as I was
Ouais,
speaking
mais là, vous me dites ça
earlier,
comme si les commissaires étaient mal
You're
intentionnés.
saying that as if commissioners have ill intentions. The commissioners need to be neutral, and they need to ensure that Parliament is functioning well without being on one side or the other. And so they need to have more powers in order to strike that balance. And you're saying no, that they should have fewer powers. I respect the work of all commissioners, all the lobbying commissioners. I think it's very important.
Because that's their job to be able to say this, what to them is the perfect world. I think for us, as we hear the examples of where we find ourselves then in the difficulty is that we would then be, how can I say, diminishing the engagement of individuals, companies, organizations with government. And that's not what we want.
Donc, les commissaires, dans leur approche...
So commissioners, because they're working for their institutions, you think that they'll do everything to have things for themselves without being there for the right reasons. But you said that we need to trust our institutions regardless of the scandals, the current scandals.
I don't think we have such scandals out there which
Une compagnie Marine Franc de Veste, 13 500 $ à louer à Nouvelle-Écosse pour...
A company and $20 million, that's a scandal, no?
It's not perfect, but I think we are at a point where to then suspect all of these, how can I say, sinister activities or illegal activities, hopefully they will be found through other mechanisms and other means, absolutely. But it doesn't mean in the example that Christina Santini gave or as Mr. Al-Soud had given, where someone walks into a coffee shop and suddenly has
Non,
to
mais ça existe pas, ça existe pas, ça. Je veux dire, 8
That
heures...
doesn't exist. We're talking about 8 hours here. Apologies, Mr. Hardy. Your time is up.
Please.
Thank you, Mr. Chair. My first round of question is for Ms. Santini. So, Ms. Santini, do the current lobbying rules place a disproportionate burden on small business and business associations compared to large organizations with dedicated government relations team?
So
I'm having a tough time hearing him too, Mr. Shore.
So absolutely, it can create a disproportionate burden compared to larger corporations because large corporations can hire law firms, consultancies, etc. Whether a small business, if suddenly they have an issue and they need to, or they're filling up an application form for a GNC, they don't have a dedicated team to do it. As we said, most of our members have 9 employees or less, so it's the business owner that's completing those forms or that is looking into the issue, that's researching it, that's trying to figure out compliance and asking for a reconsideration decision or trying to let their MPs know that this issue or this policy doesn't make sense for their kind of business and this is why it should change. Yes, you know, for some, they may say they're advocating. From a business owner's perspective, they're just trying to share their views about their business. So ultimately, 8 hours, is that too much? When it comes to the G's and C's forms, when it comes to the applications, yes, because those are time-consuming. You know, I'm sure you've reviewed the Canada Summer Jobs applications and other grants applications that may have come by your way or that your office has helped constituents with. They take time. So carving that out will help. But business owners can quickly get to 8 hours or can quickly start asking themselves the question, does this cover me? A higher threshold might mean that they don't have to stress out about it. Again, let's consult on what that threshold could be, but we can sometimes face members that suddenly have an issue with CBSA and importation fees, and they're not regularly lobbying, but suddenly spending a lot of time on a financially related question. So that's just one of the things is you want to ensure that these individuals can feel that they can reach out their MPs and that they're not suddenly going to have to face AMPs or whatever repercussions the lobbying commission, the Office of Lobby Commissioner might be considering. When really they were just trying to express themselves. So that's the other thing is whatever changes are made in the code, remember that when it comes to small business owners, educate first. So that would be one of the key things. And right now we're trying to make sure our members have the information they need and know that which resources to get so that they can be compliant with the law. Fundamentally, they don't want to break the law. And just a higher threshold will help them be compliant if they ever raise such an issue.
Okay, so Mr. Chang, I've stopped your time. Mr. Shore has something to add to Ms. Santini's response. If you want to give him that opportunity, you can.
Of course.
But I'm certain that your microphone has to be a little bit closer to your mouth, even if you hold it, because we are having, it is muted, we're having trouble hearing you. So I'm going to start your time. If you do want to give Mr. Shore an opportunity to answer the question.
Yes, please.
Okay, Mr. Shore, go ahead.
Thank you, Mr. Chang. I agree completely with what Ms. Santini just said, but I wanted to also say companies, organizations, multinationals, they understand all the work that has to go into registering and the efforts that are made to make sure that everything they do with government is transparent. It's part of the cost of doing business with government. And I think that's another part which we have to think about when we're trying to look at where we actually put the obligation on individuals or small organizations or small, these tiny companies that are actually just trying to get through the month and pay the bills that they need to. It's a big difference. And it's never been an issue for me when I'm dealing with any of those corporations that I deal with for them to understand it's simply the cost of doing business with government.
Well, thank you. Thank you, Mr. Shore. I also have one question for you. So you state in your brief that granting the lobbying commissioner independent regulation-making authority would constitute significant institution outreach, blurring the line between enforcement and lawmaking in a way that is seriously inconsistent with the fundamental principle of Canadian administrative law. As a member of parliament, I found that a bit concerning, and I want to give a chance, a full opportunity to expand on this statement.
Thank you very much. Absolutely.
And if you're running out of time, I would appreciate a written response, please.
Well,
we have a minute.
And I think we're pretty clear. Thank you again, Mr. Chang. But it's a question of the fact that in these circumstances, it is, again, respectfully, this is a commissioner of lobbying that it works hard, and I know that she has significant responsibilities, so I applaud her. But at the same time, I also recognize that the deep roots in the common law, in administrative law, that those who are involved in enforcing legislation do not make the regulations. And this is where I believe it is extremely important for that to be addressed by Governor Council through consultations within government. You wouldn't expect someone to actually create new rules on their own and then essentially enforce them. And here, the kind of issues we're talking about do have significant dollar and cents values, aside from the fact that it may very well reduce the amount of conversation, communication with government. So even more so when we're looking at these issues. So this is why I say it cannot be left to a commissioner of lobbying, as it wouldn't be left to other commissioners to take on rules and responsibilities that they simply wish to take on without engaging properly with the legislature or with the appropriate elected officials that are involved.
Okay, thank you, Mr. Shore. That concludes the time for this first panel. I want to thank all of you for appearing on behalf of the committee. And like always, if there's something you think about on the way home that you felt you should have said today, or a question that perhaps wasn't answered, feel free to submit that in both official languages to the clerk. We're going to suspend for a couple of minutes. And thank you, sir. Okay.
Thank you.
We're going to suspend and come back for the next panel in a minute or two. Before I introduce our witnesses, I just want to remind them again that committee members may ask questions in English and in French, we try to give interpretation a little bit of time. So take a moment to listen to what is being said and completely said before you respond. For the second hour today, I'd like to welcome our witnesses. As an individual, we've got Kyle Larkin, who is present before us, who's the President and Chief Executive Officer of the Canadian Meat Council, and from Imagine Canada Online, Jodine Baker, who is the Vice President of Research, Advocacy, and External Relations. Mr. Larkin, welcome again to committee. I think you were here a few years back for a lobbying study as well, and you have up to 5 minutes for your opening statement. Go ahead, sir.
Thank you, Chair, and thank you to the members of the committee for inviting me today. My name is Kyle Larkin, and I am appearing before you in my capacity as a not-for-profit executive who has spent more than a decade engaged in federal and provincial lobbying activities. The views I express today are based on my own experience as a government relations professional and do not reflect the positions of any organizations with which I am currently affiliated. I appreciate the opportunity to discuss the Lobbying Act, which governs my professional activities on a day-to-day basis. I would like to begin by addressing several recommendations recently presented to this committee by the Commissioner on Lobbying that raised significant concerns for not-for-profit associations. First, the Commissioner recommended amending the Act to deem members of boards of directors to be employees. While this may appear to be a modest change, it would significantly expand the scope of both the Act and the Commissioner's mandate by capturing Canadians who volunteered their time to serve on not-for-profit boards. Individuals who are not professional lobbyists, including farmers, nurses, engineers, and other community leaders, could be required to register simply for advocating on behalf of their neighbors, colleagues, and industries. Secondly, the Commissioner recommended requiring the disclosure of all entities with a direct interest in the outcome of lobbying activities. By their very nature, associations are a collective of individuals or organizations united around a common purpose. This proposal would require many not-for-profit associations to publicly disclose and continuously update their membership lists. For associations with individual memberships, this could mean publishing the names of tens of thousands of individuals in a public registry, despite those members never having agreed to such disclosure. Thirdly, it was recommended that the Act be amended to require disclosure of all funding provided in support of lobbying activities. Given that advocacy is often a core purpose of not-for-profit associations, this proposal could effectively require the disclosure of nearly all membership dues and funding sources. With many not-for-profit associations being comprised of small teams and operating on limited resources, this could create a substantial administrative burden while providing limited additional transparency. Finally, the Commissioner recommended requiring all communications with designated public office holders to be reportable, regardless of whether those communications are oral, written, or prearranged. This would mean that even unsolicited emails that are never opened or responded to could become reportable communications. It would also require both lobbyists and public office holders to account for virtually every interaction they have with one another. Such interactions could include passing one another on the street, exchanging pleasantries at a reception, or encountering each other at the airport. The result would be hundreds of thousands of additional communication reports and a significant administrative burden for both lobbyists and public office holders. These recommendations, along with others advanced by the Commissioner, would not only have a disproportionate impact on not-for-profit associations, but would also increase regulatory complexity for lobbyists and public office holders alike. Moreover, ongoing ambiguity within the Act, combined with limited parliamentary oversight, has resulted in evolving interpretations that continue to create uncertainty within the profession. One example is the 2023 revision of the Lobbyist Code of Conduct, particularly with respect to hospitality. Despite testimony before this committee indicating that the $40 hospitality threshold for food and beverages would be adjusted for inflation, that threshold has remained unchanged since 2023. Without a meaningful adjustment, parliamentary receptions hosted by not-for-profit associations, an important forum through which Canadians can engage with their elected officials and senators, may become increasingly difficult to organize and sustain. In closing, lobbying is already among the most highly regulated professions here in Canada. Lobbyists are committed to operating transparently, ethically, and accountably. At the same time, we must ensure that our legislative and regulatory frameworks remain practical, internationally competitive, and respectful of the important role that not-for-profit organizations play in representing Canadians. While there's certainly room to improve the Lobbying Act, any reforms must preserve Canadians' fundamental ability to participate in and advocate within our democratic institutions. Thank you again for the invitations, and I'd be happy to take any questions.
Okay, thank you, Mr. Larkin. You get an ethics participation ribbon for being under 5 minutes. Appreciate that. Ms. Baker, you have up to 5 minutes to address the committee. Go ahead.
Thank you. Good afternoon, Chair and members of the committee. Thank you for the opportunity to appear before you today. My name is Jodine Baker, and I'm the Vice President, Research, Advocacy, and External Relations at Imagine Canada. Imagine Canada is a national charitable organization dedicated to strengthening Canada's charitable and nonprofit sector through research, advocacy, and sector-wide initiatives. Canada's charitable and nonprofit sector includes more than 170,000 organizations working in communities across the country. The sector contributes 8.4% of Canada's GDP, employs nearly 3 million people, and is supported by approximately 13 million volunteers. Organizations across our sector work every day on issues such as housing, poverty, disability inclusion, mental health, and newcomer settlement, to name a few, giving them direct insight into community needs and the impact of public policy. The nonprofit sector supports transparency and accountability in public decision-making, and we support the objectives of the Lobbying Act. The issue before this committee is not whether transparency matters, it is whether the Act continues to strike the right balance between transparency and participation in public policy discussions. Recent changes to the interpretation of the in-house lobbying threshold have created significant concern across the nonprofit sector. For many nonprofit organizations, engagement with government is not carried out by dedicated government relations staff. It is often one responsibility among many for executive directors, program staff, researchers, and other employees. These organizations participate in consultations, respond to requests for information, and provide evidence and expertise to government. As organizations have worked to understand the implications of the new interpretation, we have heard concerns about administrative burden, uncertainty regarding what activities count toward the threshold, and the risk of unintended non-compliance. For many organizations, the issue is not just the threshold itself, it is also the loss of predictability that comes when a long-standing interpretation changes. Ultimately, the larger question before this committee is not simply where the threshold should be set. The more fundamental question is why Parliament included a threshold in the first place. Consider a small nonprofit delivering services in its community. An executive director might spend a few hours responding to a government consultation, participating in a discussion about program design, and another staffer may share what they're hearing from the communities they serve. The question is whether these are the kinds of activities Parliament intended to capture when it established the significant part of duties threshold. Parliament could have required registration for every interaction with government, but instead chose to distinguish between sustained lobbying activity and occasional engagement. That distinction helps focus transparency requirements on significant lobbying activities while recognizing that engagement with government is often a normal part of how charities and nonprofits fulfill their missions. Transparency matters, but participation matters as well. As Parliament considers changes to the Act, it's important that registration requirements do not inadvertently discourage charities and nonprofits from participating in public policy discussions. Transparency also depends on organizations being able to understand and comply with the rules. Clear and predictable requirements make compliance easier and more effective. For that reason, our primary recommendation is that Parliament clarify the meaning of significant part of duties so that it captures significant lobbying activity while avoiding unintended consequences for organizations whose policy engagement is limited or incidental. More broadly, Parliament should ensure that the Act is applied proportionately and reflects the realities of nonprofit organizations, where staff who engage government are often also responsible for program delivery, fundraising, volunteer management, and community engagement. The Lobbying Act should promote transparency while ensuring charities and nonprofits can continue to contribute their expertise and community perspectives to public policy discussions. Thank you. I look forward to your questions.
Okay, thank you, Ms. Baker. We're going to start with our 6-minute rounds. Mr. Barrett is going to go first. Go ahead, sir.
Mr. Larkin, you raised concerns about the broader registration rules. Can you give the committee concrete examples of where that disclosure itself would discourage legitimate participation in policymaking? And I know that you spoke to administrative burdens. Could you expand on that, or just expand on that a little bit for our benefit?
Yeah, the third recommendation that I highlighted from the commissioner was around adding to your registration all of those that benefit from your lobbying activities. And so for not-for-profit associations that may have 1,000 members, 20,000 members, 100,000 members, who could be nurses, farmers, et cetera, all of them would benefit from the outcome of the lobbying that those associations participate in. And therefore, or at least my interpretation is that the membership list would need to be included in the registration. The other piece on volunteers versus paid employees, since the Lobbying Act was created, there's always been a distinction between paid employees and volunteers. The recommendation that the commissioner put forward would loop in volunteers into that registration. So for boards of directors that I have worked in the past, where it's individuals, be they farmers or whomever, who are volunteer their times to be on these not-for-profit association boards, now they would have to create their own registrations with the lobbying commissioner, despite receiving $0 from the not-for-profit association. So those are some of the challenges that I highlighted.
And do you think that would reduce participation by those volunteers?
I think there could be a case of that, but I think it's a bigger question of, small and medium-sized enterprises, or even just Canadians getting involved in not-for-profit associations, advocating on behalf of their industry, advocating on behalf of their neighbors, colleagues, then having to register for something that they didn't need to before, and that, to be frank, shouldn't be a requirement because they receive $0 from their activities. They're really just advocating on their own volunteer behalf. And if you follow that path down the line, then we get to a world where, your small business in X constituency advocates to their local member of parliament for an immigration issue or a CRA issue or whatever it might be, and then them needing to register and report. And I know that Jodine spoke a bit about the 8 hours versus 32 hours, the definition of what is a significant part of duties. You also start to go down that path that really impacts small businesses, or even just individuals who are advocating to their local member of parliament.
When someone helps to shape policy or they influence a change that materially benefits their employer, their organization, or their client, what do you think is the level of disclosure that Canadians are entitled to?
Great question. I think the level of disclosure is currently available through the lobby registry in terms of disclosing money received from government, disclosing all of your subject matters that you're lobbying for, disclosing all the meetings that you've had that are prearranged and oral. I would say the way that the current federal lobby registry is framed is through a transparent method. And as a lobbyist for 10 plus years, I believe in transparency. I believe in Canadians knowing everything that I'm doing as a lobbyist and the individuals that I meet with. But there needs to be a line between transparency and an overburden on not-for-profit associations that may just have 1, 2, 3 employees.
And this should be reserved for people who are being remunerated and not capture volunteer activities.
Correct.
And well, thank you very much for your reply. And is it Ms. Baker? Ms. Baker, you had raised the threshold that Parliament had originally included, and that was so that ordinary Canadians, small businesses, charities, local organizations wouldn't be buried in paperwork for that occasional contact with government. What kind of reform or what kind of change should take place so that we preserve that protection?
So in our submission, the recommendation we have made is to, we put going back to the 32 hours. I think that fundamental question is reference to a threshold at all in legislation. So the commissioner has recommended registration by default, which would remove that. And our recommendation is to retain that and have it more clearly articulated within legislation around what that threshold should be.
And is the number important? Is 32 hours important? What do you think? Like how would you design in 30 seconds or less? I think is what the chair will tell you. How would you design it?
Yeah, I think we're not going to come. I don't think I would come to that number today. I think I've heard other witnesses mention the need for consultation. I think it is about balancing the transparency piece along with the participation aspect.
So avoiding, any kind of sophisticated effort to exploit loopholes.
Yes.
Thank you.
Okay. Thank you, Mr. Barrett. Mr. El-Soud for 6 minutes. Go ahead.
Thank you, Chair, and thank you both for taking the time to be with us today. Ms. Baker, for several years, I had the privilege of working and volunteering for the Canadian Red Cross, primarily in fundraising, philanthropy, and stakeholder relations, as well as in disaster management and emergency response. The CRC is, if I recall correctly, a member of Imagine Canada, so I start by taking a moment to thank you for the work that you do. My time at the CRC intersected with some of the most significant challenges the organization has seen in its history, tied to the various natural and conflict-related catastrophes, and so I say the following with every conviction in the world. The nonprofit sector plays a fundamental role across our country, doing some of the most important work of all, often with far fewer resources than they certainly might need. As we conduct this review of the Lobbying Act, I'd like to offer you the opportunity to speak to the importance of that work, as well as on the importance of striking the balance between transparency mechanisms while ensuring that unintended consequences do not end up disproportionately impacting them.
Thank you for your question, for your previous work in the sector. The nonprofit sector really is the connective tissue between what Canadians are experiencing in their everyday lives and the government. So having that line of communication between charities and nonprofits and the government is essential to a healthy and functioning democracy. We support transparency, so we do believe that if there are charities and nonprofits engaging in sustained lobbying activities, that is something that should be registered and reported on. However, if you get into that tipping point where there is the burden of reporting, what happens is you risk, again, both the burden of work, which means those staff at charities and nonprofits have less time to put towards the actual delivery of programs and services, and you risk a reluctance to even engage with governments, which means that government is now missing important information to inform their program and policy design.
Fantastic. Now, your brief touches this to some extent. I'd like to ask you the question, how do you believe the Lobbying Act could introduce more proportionate reporting approaches for smaller organizations?
Yeah, I think the first point is maintaining a distinction between sustained lobbying and occasional engagement. So maintaining a threshold, our recommendation would be to go back to the 32 hours. And then also this would go over to the Commissioner's office around clarity around what activities do and do not count. And so that's where we've been seeing some confusion over the last several months around activities such as preparation for meetings. We've heard a lot of references to work related to grants and contributions. So more plain language guidance, perhaps an online tool specifically for charities and nonprofits to help them navigate the regulation and compliance environment more efficiently.
Perfect. The sector will often see collective advocacy efforts. In your brief, you note in Recommendation 3 the need to clarify the treatment of coalition and sector-wide advocacy. Could you speak to this a little more?
Yes, the nonprofit sector, because so many charities and nonprofits are small and do not have the capacity to hire full-time government relations staff, we rely on strength in numbers. Imagine Canada, for example, often plays a backbone role to coalition work, where we will do a lot of the coordinating and organizing, such as the Lobby Day. There is uncertainty right now and nervousness among the nonprofit sector around which of those coalition activities require registration or require to be counted in the tracking towards the threshold for lobbying. With that reduction in the number of hours from 32 to 8, there's just a more attentiveness and more attention is being paid to it because there's a recognition that that number might be met more quickly than it has been in the past. So the need really we're recommending is just clarity around how coalition activities are tracked and lobbying and what is included in it and is not included.
Thank you, Ms. Baker. Mr. Larkin, I turn to you now. Before this committee, we've had the opportunity to hear from federal and provincial lobbying commissioners, legal experts, and academics. I think it's also important that we get to hear from someone who has practical, on-the-ground experience at understanding how the Act works in practice. I have a big question for you. What's working well, what isn't and needs reform, and what suggestions would you like to put forward to this committee?
Great question. Thank you for it. What's working well, I think, is the lobby registry. I have registered in every single province in Canada, and so I can compare the federal registry to the systems that I've used at the provincial level. I can tell you some at the provincial level, such as the one in Saskatchewan, absolutely fantastic. Others need some work. They need a new web developer. But the one federally is actually very accessible. It's accessible by lobbyists. It's accessible by the public. It's accessible by public office holders. A very easy tool to find out who is lobbying, who's lobbying for what. I believe the transparency through the system right now is at the right level in terms of showcasing the subject matters you're lobbying for, who you've lobbied, when you've lobbied them, what you've lobbied them on. Also includes government funding and other aspects like that. So I think that is working really well. The main element that I think is concerning is the interpretation of different things from the Lobbying Act, and I touched a bit on that in my opening remarks, because things are interpreted by different people in different ways, and so the Lobbying Act and the significant part of duties section, for example, has been interpreted by commissioner after commissioner after commissioner to be 32 hours. The newer-ish commissioner has interpreted now that to be 8 hours, despite no evidence showing that there's been shadow lobbying or negative lobbying or anything that led from a 32-hour to 8 hour. So I question the interpretation there. The second piece I question is the interpretation on the hospitality level. That has been interpreted to be $40 when the Lobbyist Code of Conduct was renewed in 2023. It hasn't been updated since then. And so if we want to continue holding parliamentary receptions by not-for-profit associations that I know many of you in the room attend and enjoy, and is a great opportunity for you to connect with Canadians in Ottawa instead of having to, go across the country trying to attempt to connect with these Canadians. That supports your parliamentary role, your committee roles, et cetera, your role in the House of Commons. We need to ensure that level meets inflation and is increased. $40 was great in 2023, but it needs to be updated in 2026.
Thank you, Mr. Larkin. Mr. Alsoud. Monsieur Fortin pour 6 minutes.
Merci, Monsieur le Président.
Thank you, Chair. Thank you, Mr. Larkin. Thank you, Ms. Baker. Ms. Baker, my first questions are for you. The Commissioner recommends disclosing all foreign funding sources. Do you think that non-government funding, rather, including foreign funding, is this a good idea in your view?
Thank you for the question. This isn't an issue that we've considered in our submission, and so I don't have the experience to speculate on that today, especially speaking on behalf of an organization, but that's something I'd certainly be willing to look into with some of our members and others across the sector and provide an answer to you at a later date.
Est-ce que je veux juste m'assurer que je comprends bien?
I just want to be sure that I'm understanding your response. Your organization does not receive any funding outside of government funding? Your only client is government? Is that correct?
No, I'm saying for me our Imagine Canada does receive donations from foundations, for example, grants from donations. I'm not sure that I could speak in terms of changes to the Lobbying Act as it relates to the entire sector.
Okay. Vous ne savez pas si ce serait une bonne idée.
So you don't know if it would be a good idea to require disclosing those funding sources? Is that what you're saying?
Charities already do disclose their funding sources with their reporting through the Income Tax Act. So I think I may not be understanding the question that you're asking. If you could rephrase that for me.
Simplement que le commissaire recommande, c'est
the Commissioner, in Recommendation 8, recommends the disclosure of all funding that is non-government sources of funding. So any funding outside of government funding. And this includes foreign funding as well. There have been some concerns in the past years, and I'm sure you're aware of all the matter of foreign interference, especially in the electoral process. And so we are concerned by those issues. And perhaps the Commissioner's recommendation could protect us from some of that influence. But I don't want to force you to respond. If you don't want to have an opinion on that, that's okay. I can move on.
Yeah, at this point, I think it'd be. I think I'd like to reserve to think some more on that topic.
OK, merci. Monsieur Larkin, la même question pour vous.
Mr. Larkin, same question for you. Recommendation number 8 regarding non-government funding. Do you think that that's a good idea, requiring a disclosure?
Or worked with a not-for-profit association that's received funding from, international organizations or from other means.
Et dans votre cas, vous êtes avec le Conseil des viandes du Canada.
You're
Donc,
with the Canadian Meat Council, and I imagine that your only clients are government?
The main dues are from the members. We receive some government funding to do different programming, and the associations I've worked for before similar, where the lion's share is membership dues with a very small portion of government grants to enact different programs that the government is looking to accomplish.
La question de l'enregistrement.
Now, regarding registration by default, do you think that that's a good idea, or do you believe that we should go back to the 32 hours that we had previously or the 8 hours that we have currently?
It's extremely concerning, and I would flow into that needing to put in communications reports by default, with it changing from the oral and arranged, which is currently the case, to any instance of communications with any designated public office holder needing to be registered. So that's what we've seen in British Columbia. They have had to change some of their rules because things have gotten so onerous, where if someone put out a Facebook post that said, Premier David Eby, you need to do this, you would need to put in a communications report for that Facebook post. Or if I sent you a meeting request to say, Mr. Fortin, can you meet me on X and X date, and you missed the email, you didn't even respond to the email, that email would need, there would need to be a communication report behind it. So both of those things play into each other, but registration by default is extremely concerning, especially when you look at not-for-profit associations that represent either individuals or small and medium-sized enterprises across Canada. If those individuals are advocating on behalf of their small business or for their individual business, registering by default would mean that most Canadians who liaise with their member of parliament for one issue or another would need to register.
À votre avis, est-ce que le commissaire pourrait en faire davantage?
Could the commissioner do more in order to help nonprofit organizations in meeting their obligations?
The Office of the Commissioner of Lobbying, they already do that. And so I would give them thanks for doing that. They're always open to answering questions. I've worked with many different associations who haven't understood one part or another of the Lobbying Act or the Lobbyist Code of Conduct. And anytime we reach out to the office, they always come back to us with a good answer.
Le commissaire demande un éventail de sanctions.
The commissioner is asking for expanded penalties, and you can see that in recommendation 17. She's recommending mandatory training, administrative monetary penalties, and temporary prohibitions on lobbying. What do you think of these measures? Does it make sense for the commissioner to have more powers for these penalties?
The lobbying commissioner has right now are sufficient in terms of being able to loop in the RCMP, levy fines, and greater penalties than that.
Okay, merci, Monsieur Fortin. Mr. Cooper, 5 minutes, starting the second round. Go ahead, please.
Thank you, Mr. Chair. I'm going to direct my questions to Mr. Larkin, and I take your point, but I'm going to push back a little bit on your submissions with respect to the Commissioner's recommendation around communications, whether they be oral, written, or prearranged. At the end of your testimony, you suggested that this could result in having to issue or to file a report upon there being any communication with a public office holder, running to a public office holder at an airport lounge or on the street. But when I look at the Act, in terms of what constitutes lobbying, it relates to a communication with respect to the development of any legislative proposal, the introduction of any bill or resolution in the House, the making or amendment of any regulation, the development or amendment of any policy or program, the awarding of any grant, contribution, or other financial benefit, or the awarding of any contract. That seems very different in substance than simply running into a member of parliament or a senator and saying hello at an airport lounge.
Great question, Mr. Cooper. Thank you for the question. So I'd say two things to that. First of all, on the section you read of the Lobbying Act, that is definitely correct. And I would say that really influences what is a registrable activity, what requires not-for-profit associations to register. And having worked in the consulting world and worked with many different associations, the question we always got was, should I register? And our answer, 99% of the time was yes, you should register. The other issue, though, is when and if a communications report is required. So, if I, as a professional lobbyist, am at a reception and I run into 5 members of Parliament where I want to talk to them, hey, how is this act going, or how's this bill going, or have you heard about this regulation, or have you heard about this issue? Quick 30-second conversations like that at a reception over a beer or a cocktail now would need to be would require a communications report. The same would be for social media posts. So if an association puts out a post says, Prime Minister Carney, you need to do X, Y, or Z, that is now requiring a communications report. So it really opens the Pandora's box for a communications report, which I think is extremely concerning. And as I said, British Columbia has already opened that Pandora's box. It's not an area I would recommend the federal law going in.
So your recommendation is just to leave it as is?
I believe
because I take your point. I take your point up to a point. But it seems to me that for many circumstances where communications are happening that go to the heart of what constitutes lobbying under the Act, and that for technical reasons, there is no legal requirement to file a report or to register. And it is that has concerned the lobbying commissioner. So what is your response to those activities beyond a very brief interaction with a member that really is not all that substantive in moving any kind of needle?
It's a great question, and I just believe that there needs to be a line created, and I think that line for years now has been created on oral and arrange, and for right reasons, where if I set up a meeting with you, Mr. Cooper, and I lobby you on X, Y, or Z, there's a formal agenda. We've both agreed to participate in that activity of me lobbying you or advocating on behalf of a different industry or different professionals. And so when I put in a communications report, and if the commissioner calls your office and says, hey, did Mr. Cooper meet with Mr. Larkin on June 1st, 2026 to discuss XYZ, your staff or yourself would have notes that, yes, we did meet, and you can confirm that. And the commissioner does do spot checks like that with public office holders. So if we eliminate the need for oral and arrange, all of a sudden, not only is there a plethora of extra communications reports coming into the office, but public office holders, designated public office holders now would also need to recall every interaction they've had with an individual, a lobbyist at Tim Hortons or at a reception or at the airport, et cetera, where that individual brought up a bill or a regulation or some kind of program or something else. So that's where I find there's an issue where things grow.
Okay. So as I take it from your answer, your position is with respect to the reporting requirements to maintain the status quo. Do not make a change is your recommendation.
Yes, exactly. I think oral and arrange works the best because that's when real formal lobbying and the actual act of lobbying happens.
Okay, thank you.
Mr. Cooper, Madame Lapointe pour 5 minutes.
Ms. Lapointe, you have 5 minutes. Thank you, Chair. I was surprised to see you as one of our witnesses today. Usually we see you at the International Trade Committee, but given that you're here today, I think that you are well placed to speak to us about the Lobbying Act, and I was surprised to see your name, though. But I'm happy that you're able to talk about it. Have you been doing this for a long time?
I'm extremely passionate about. I used to work on Parliament Hill for a few members of Parliament, receiving lobbying on the other side, and I wanted to get into this profession, and I've enjoyed it ever since.
Donc, on parlera pas du porc et du bœuf
So
aujourd'hui.
we won't be talking about pork and beef today. Do you think that the 10-day deadline, I know that you referred to it earlier, so that 10 days proposed by the lobbying commissioner, is it appropriate? We've heard from other witnesses today, and Ms. Sabourin, for example, and Mr. Shore are also here. They spoke about a 30-day deadline. Do you believe that a 30-day deadline would give lobbyists enough time and ensure that there isn't any non-compliance?
I've been in a position where I've seen former clients of mine where, you know, life's just sometimes gets in the way of things. You lose a loved one, you go on vacation, something happens in your life where, you know, you had a lobbying meeting on the Friday and then you're out of the office for the next 3 weeks because something unfortunate happened. So I think providing as much flexibility to lobbyists as possible while also ensuring that the act and the code and the way that lobbyists are treated is still transparent, because I think transparency and accountability are paramount for the profession. We already have much of a negative connotation in the public spheres. We need to ensure that Canadians know that we're as accountable and as transparent as possible. So I think, yeah, the allowing as much flexibility as possible is good.
OK, merci. Ben, je comprends ce que vous voulez dire.
Thank you. I hear what you're saying, that 10 days is quite difficult. Given that you're part of the Meat Council, how do you give to government the proper expertise for making good policies?
With provincial and national not-for-profit associations for about 10 years now as well, in many different industries, from farming to meat to intellectual property to construction to chemistry, all over the board. And all of them, the role I think they play here in Ottawa and with parliamentarians, but even in provincial legislatures, is really a bastion of information. You folks know you do not have the time to meet with 100,000 farmers or 20,000 auto workers or 50,000 people who work in our forestry sector or whatever it may be. But that's why not-for-profit associations exist, so that you can meet with one individual or a few individuals who represent that industry. They can provide you a more general area of the issues the industry is facing, what works well, what doesn't work well in terms of bills or acts or regulations or programs, et cetera. And their role is fundamental, I think, to Canadian parliamentary democracy in terms of shaping various policies, shaping various legislation. They represent Canadians and Canadian businesses that otherwise wouldn't be represented here in Ottawa.
Merci, très intéressant. En passant, je t'en
That's very interesting. I started as the treasurer for the food retailers, and so this is what brought me here. And now, in your experience,
is the intended purpose of what Parliament, the House of Commons, and the Senate intended it to be. But as I said earlier, there's always an issue in terms of interpretation of the Lobbying Act, which is the role of the Commissioner. And from my previous experience, I find that the parliamentary oversight on the interpretations isn't fully understood. And so interpretations can happen that really impact the profession day to day without any recourse from this committee or from the House of Commons or from our elected body here in Canada. So that's always been a concern. One area I would say in terms of the Lobbying Act where it could be improved is the 5-year lobby ban. So Canada, when we look internationally, what do other countries internationally have as a lobbying ban? So you're a designated public office holder, you want to get into lobbying, how much time, a cool-off period do you have? Here in Canada, it's 5 years. The average internationally is much lower than that. If you take an average of all our kind of OECD or G7 partners, you're looking at 4 years. So we're 1 year above. That's why I said in my testimony that we have one of the most onerous lobbying acts in the world, and it really prevents a lot of young. What I've seen in my career is a lot of young individuals. It prevents them from getting into lobbying or even getting into a minister's office or into some designated public office position.
Merci beaucoup. Merci.
Thank you, Mr. Larkin.
thank you. Thank you, Ms. Lapointe. Mr. Fortin, if you want 5 minutes. Yes, thank you. Mr. Larkin, we saw that the Yukon added a concept regarding lobbyists. So it includes entrepreneurs and others. What would be the usefulness of that? Is this something that we should include in our lobbying act here, or would it not change anything?
And even though I've lobbied in every single province in Canada, I haven't lobbied in the territory. So I've never been registered in the Yukon. But I think we see there's a similar system, from my understanding, in Alberta, where you have an account manager and then you have all the lobbyists that kind of fall under that. At the federal level, we see that already for in-house organizations where the senior most officer, so myself, for example, at the association I work at right now, is the registered individual, and under my name are all of those at the association that lobby on behalf of the organization. I think at the federal level, the way that in-house registrations are encapsulated and built is the right direction to go. I think it would be quite onerous for each individual in an association to have to create their own lobby registry when we're all advocating on behalf of one association, on behalf of one set of issues.
Et je crois pas vous l'avoir posé, mais mémoire.
I don't think I've asked you this, but board members, should they be considered lobbyists as well? And should they have different obligations?
Don't pay their board of directors because they don't have money to pay their board of directors. So most of the individuals on the boards I've worked with in the past are volunteers. They're volunteering their time because they're passionate about their industry. They're passionate about growing their industry and ensuring that their industry is successful. I do not think those individuals should need to register. They lobby on a very infrequent basis. So if we have a lobby day here in Ottawa, for example, bring the board of directors in and they meet with 20 members of parliament in one day, that's maybe the limit of the advocacy or the lobbying work that they're doing in 1 year. I don't think that those individuals should have to register. They are volunteers. And again, I think it opens a Pandora's box. If we start to look at volunteers as professional lobbyists, how does that apply to the coffee shop in your constituency or the small business in other constituencies, et cetera? We start to go down a slippery slope, in my opinion.
Oui, mais vous dites, bon.
You've said that these volunteers are passionate, and so they are lobbying for their organization in support of the mission of the organization. But remuneration is not the right word, but they do benefit in a way. Is it not important to make this communication open, whether it happened through a volunteer or an employee? If there's a difference there, you can explain it to me, but for the Meat Council, they're communicating with the finance minister, whether it's done by the director of the board or an independent lobbyist or a volunteer. That's still that's still lobbying. Should it not be treated the same?
There is a distinction between professional lobbyists who are paid and volunteers on board of directors who could be day-to-day farmers, nurses, engineers, teachers, you name the profession. I still believe very fundamentally there needs to be a distinction between those two individuals. Professional lobbyists like myself over the past 10 plus years, every single day is about lobbying. Every single day is looking what's happening in the House of Commons, what's happening at these committees. Okay, we need to meet with these members of Parliament on this issue. We need to, meet with these ministers or minister's office on this issue. Every day as a lobbyist, you're thinking about lobbying. You're thinking about, okay, how can I influence the government of Canada to go one way or another on, a policy or a program that impacts 100,000 Canadians or 50,000 Canadians. That's the day-to-day life of a lobbyist. the day-to-day life of individuals who volunteer on boards of directors. They maybe meet 4 times a year, and one of those meetings is here in Ottawa where they meet with a few members of parliament. Otherwise, they're tilling their fields, they're nursing patients, they're teaching children, they're doing their actual job. Just because they're volunteers on board of directors, I don't think should require them to have to register.
Et dans le même ordre d'idée, les lobbyistes conseils versus les lobbyistes salariés.
Now, consultant lobbyists versus in-house lobbyists. Should they have the same rules to follow, or should there be a distinction?
Oui.
Consultant lobbyists? For example, a lobbying firm that represents or who has many clients and they are lobbying the government. They are full-time lobbyists, that's all they do, but they do it for different clients versus an in-house lobbyist who works for a company, does the same kind of lobbying but has only one client, their employer. Should there be a distinction or should the obligations be the same?
Consultant lobbyist, and I've been an in-house lobbyist. I would say the registration details and the registration requirements right now are very similar, and I would keep what is currently built.
Okay, thank you. Merci, Monsieur Fortin. Monsieur Hardy pour 5 minutes.
Thank you, Mr. Fortin. Mr. Hardy, you have 5 minutes.
Nous?
Thank you. I would like for us to clarify that lobbying is important. I have repeated it here. MPs don't know everything, and we need to get information on these different industries through the experts. We also talked about our small businesses. 99% of businesses in Quebec are small businesses, 98% in Canada. These are people who have other things to do than just speaking to us. They have work to do, and we understand that. But you said something earlier that I want to ask you a question about. You said we need more transparency, more accountability, and there's a negative connotation when people hear about lobbying. Do you not think that we need as much transparency as possible, given that people are losing trust in the work that you're doing, thinking that people are trying to benefit themselves? Everything that we can do to improve your reputation because you're important, well, I think that should be part of our discussions.
Is further regulation, I don't necessarily think equals a more positive outlook of the lobbying profession. What we continue to see in social media or TV shows or movies, I think that will continue to happen. We'll continue to have shows like House of Cards that depict a lobbyist in a very negative light, someone who's really bending rules and doing other unlawful activities. But to answer the question that you posed, as I said at the start of my testimony, lobbying in Canada is already one of the most regulated professions, not only within our country, but even internationally. I touched on the lobbying ban, the 5 versus 4 years. But when you go when you go through the lobby registry, you can see the subject matters, you can see who was lobbied on what date, on what subject. I believe there is a great amount of transparency and accountability that the current Act and Code has right now.
Mais est-ce que vous pensez que les recommandations de la...
Do you believe that the Commissioner's recommendations are focusing on what's already going well, or do you think that she's trying to cover what she's seen? Because the structure dates back to 2012, so she is seeing new issues, and she is trying to focus on prevention by covering more potential issues. If things are working well, then that's not a problem, but I think that the Commissioner is trying to prevent potential issues that have probably occurred in the last 12, 13 years. Do you think that that's what she's trying to do, or do you think she's just trying to give herself more powers?
From my knowledge, there is no case that led from the 32-hour interpretation of the Lobbying Act to an 8-hour interpretation of the Lobbying Act. What I see nationally is really a race by commissioners as to who can make it the furthest on regulations and law. British Columbia went the furthest. I think the federal law is maybe trying to catch up to that. But that doesn't mean that the British Columbia, the law and regulations that they passed in that province are correct. In my opinion, those are overburdensome, both for public office holders and lobbyists and small and medium-sized enterprises in that province. So for me, I see it as a bit of a race between who can make it the furthest.
J'ai comme l'impression que des fois, on arrive
I get
avec...
the impression that sometimes, and I agree with you, we want things to be simple and efficient. Regardless of the government of the day, the system needs to be simple and easy, and people need to be able to work hard and without always having to fill out forms. But you might say that you have other things to do in the day, but if your goal in lobbying is to influence government for decisions to be made, whether you're doing it full-time, part-time, or as a volunteer, if your goal is to make legislative changes, regardless of whether or not you're paid, the goal is the same. So should those activities not all be covered?
I think paid professional lobbyists should have to register, especially when they're engaging in lobbying activities. Where maybe I disagree with a bit of the question is on the volunteerism side of things, especially for volunteered board of directors, who again are just individuals who are passionate about their industry, have gotten likely involved in their provincial association, then gotten involved in their national association, and then all of a sudden find themselves in Ottawa, and all of a sudden find themselves thrown into a meeting with a member of parliament.
La même chose en bout de ligne. Si c'est le même résultat qu'on cherche pour...
If we're seeking the same results, why would one activity be covered and not another? And perhaps I'm playing devil's advocate here, but if the goal is the same, what does it change whether or not one is being paid?
Volunteer directors on board of directors are very much spokespeople for the association, while paid lobbyists think of every different angle that you can, change a legislation here or there. Maybe this member of parliament will be a champion. Maybe this senator will be a champion. They think about these things on a day-to-day basis. Very much board of directors, folks who just fly into Ottawa, they're really there just as spokespeople of, this is what's impacting my industry, and this is what the government of Canada could potentially do to help us.
Vous pensez... Déjà? Encore?
Déjà.
Time's up. Yes, it is. It goes by quickly.
Love your passion, but a little over time every time, but that's okay. Mr. Millett, 5 minutes, go ahead.
Thank you, Chair. My first question is for Dr. Baker, and then I have another question for Mr. Larkin. Dr. Baker, first off, thank you very much for all you've done and continue to do on behalf of nonprofits and charities. It's a field that I'm quite well familiar with, having been involved myself in 3 decades of journalism, having chronicled the amazing work that is done by those agencies. We've heard a lot of discussion here today regarding the significant part of duties threshold. In your estimation, then, Dr. Baker, have nonprofits and charities reported difficulties in complying with the lobbying commissioner's recent changes in this regard?
Thanks for your question. I don't think this is about difficulty in following compliance. I think what it gets to is that piece around where are we focusing transparency requirements on, and is it on sustained significant lobbying versus occasional interactions. I think with the lowering to 8 hours, charities and nonprofits are becoming more and more concerned about what activities fall under that. I've heard reference today to things about, you run into an MP while you're out and about. Comments around if you are asking for a change in policy or programs, like your goal then is lobbying, your goal is change. In the charitable sector, when many EDs or staff encounter an MP, they get asked by that MP, tell me what you're seeing on the ground, tell me what's going on. And their response might naturally include things that start to reference, oh, well, this program might need to change, or it would be helpful if this policy had an amendment. And so I don't know if you characterize that as a sustained lobbying effort, or if, as I mentioned in my statement, that is just a normal part of a charity fulfilling its mission.
Okay. And further to that, then, when the lobbying commissioner changed that interpretation of the significant part of duties threshold from 32 to 8, do you know whether any consultations or engagement were made with nonprofits, charities, or small businesses to assess?
Not to my knowledge.
No?
Yeah, not to my knowledge.
So there was, you don't know how that, if you hadn't heard, and then you're one to know if there had been any of that consultation, I would take it.
Yeah, we were not aware of any.
Okay. All right, thank you. My next question then is for Mr. Larkin, and witnesses before this committee, Mr. Larkin, have described the BC Lobbying Act as the gold standard. However, based on your testimony today, it sounds as though you've got some areas of concern given your experience. Could you highlight then some of the challenges or issues you've encountered with the BC Lobbying Act that we should consider as a committee?
Thank you for the question. Gold standard for some, certainly not the gold standard for most. Having been a lobbyist in BC years past, I'm not currently a lobbyist in BC. Just for the record, I did find it quite onerous representing various associations in that province. As I said, most communications, not just oral and arrange, require communications reports in the province. So sending out a tweet that says, Minister X, please do X, sending out a meeting request that never receives a response, all of those types of items require a communications report. And I find when I was a consultant lobbyist sending out meeting requests to let's say 50 different MLAs in British Columbia, having to put in a communication report for all 50 of those, despite me only maybe receiving a response on 5 of them, I thought was a step too far. And not that it prevented transparency. I just think that it gets in the way of transparency. If we have too many communications reports for the public, for the media, for parliamentarians to look through, then we get past the level of transparency where there's so much paperwork in front of individuals that they just give up in actually looking through the paperwork. So I think that's where the BC registry and requirements went to, where I would really warn parliamentarians here to go in that direction.
And finally, I know you've touched on this to some extent, but could you explain to this committee why you believe a distinction between in-house and consultant lobbyists is necessary or not?
I do think it's necessary. The role of an in-house lobbyist is certainly different than one as a consultant lobbyist. As a consultant lobbyist, you have clients that you're lobbying for on a regular basis. In-house registrations, you may be a registered association, but you may only lobby on one-off basis, maybe once a month or once every now and then. So you're still a registered entity. You have the list of employees on your registration listed as to who may participate in those lobbying activities, but versus a consultant lobbyist registration where your role as a consultant very much is understanding the politics of the day, how things operate here in the House of Commons or in the other chamber, and really advising clients and connecting clients with designated public office holders.
Okay.
Thank you.
Thank you, Mr. Larkin. Ms. Baker, I saw you nodding your head there, and I'm sure Mr. Millett would like to give you the opportunity to respond to that last question. So even though we are over time, I'm going to give you an opportunity because I saw that you wanted to be engaged.
Thank you.
So go ahead.
Yes, thank you. I appreciate that. So for charities and nonprofits rarely have, they're in-house. And even then, it's often not one dedicated staff. And so it's very distinct. So it's being done often off the side of the desk by the ED, by the fundraiser, by the program manager. And that's where we really get into that challenge of the 8-hour threshold. I do want to make sure we have that clarity that the 8 hours applies across anyone in the organization. And that's that in-house distinction, right? The organization registers and anyone on staff who is working to meet that. That's where that 8 hours does start to become quite limiting. In that, an ED goes to a consultation, a staff member plans for a meeting, someone's having a conversation around a grant. So just to reiterate, there is that distinction between the sustained lobbying that paid consultants do and the more incidental that some of those smaller charities and nonprofits engage in.
Okay, thank you, Ms. Baker. Thank you, Mr. Larkin, for being here and providing the committee with some valuable input. I'm going to adjourn the meeting. Thank you.